So I'm going to be talking about working time, flexible and atypical workers, and what else to expect in 2024. So working times had quite a lot of focus over this year, and I really want to focus on a couple of things. So I want to take you back to quite a few years ago. I actually was on holiday in Scotland at the time, and we had the Bear Scotland decision. Some of you will remember Bear Scotland. This was all about whether an employee, when they go on holiday, is able to have their holiday pay increased by what they would normally get were they not on holiday. It's fair to say the tabloids gave this quite a lot of publicity at the time, and it resulted in quite a lot of claims and an awful lot of speculation and assessment and how do we stop this, and lots of noise, perhaps to deprive those employees of what they could be getting. But most of the time, it's trying to work out what the employee or worker should be entitled to. The latest in this saga, and it's been going on for many years now, is how far back can the person go back, too many backs, in their claim. So what we're talking about here is the Agnew decision. So current law is that if there is a series of deductions, so what I mean by that is, so every time I take holiday, I am not paid all of the holiday pay that I should be paid. Currently, if that happens each month, I can go back a long time. But if there is a 3-month gap when I am paid correctly, or perhaps I don't take holiday, then that may break the series of deductions, and therefore anything that any period of underpayments before the break fall away and are out of time. In GB, we have a 2-year backstop in any event. But in Northern Ireland, they don't have the 2-year backstop. And the Agnew case is by a group of police officers who are not employees, who are workers, who brought claims for unlawful deduction from wages and said, we believe the artificial break shouldn't stop the series of deductions going through. So in other words, I'm sure you're with me, if you've got 10 years and throughout that period, you've mostly been underpaid, but there have been periods where either you've not taken holiday or you have been paid correctly, you should look at it holistically rather than trying to take a analytical approach to, there was a period where it was there wasn't holiday pay, wasn't holiday taken, or it was paid correctly. The Agnew decision is that such a break won't stop an overall series of deductions, and therefore the police officers can go back to potentially the date of commencement. That is apparently worth £30 million, so quite expensive for Northern Ireland to fix. So they've basically said, and it's binding over here, the tribunal will have to decide what it means. So as I say, over here we have the 2-year backstop, but within the 2-year backstop, we are not able to run a break in the series of deductions argument. There was a bit of a question mark over whether the 2-year backstop will still apply over here. There's some arguments about that, but certainly from the new year, given the principle of equivalence and how we've implemented all of that and EU law, new claims will definitely apply with 2-year backstop, may not be for new claims now. But I don't think this is going to be a massive wave of new claims, but I am continually surprised that I talk to employers and say, you are paying holiday pay correctly, aren't you? And you get that slightly blank look, and then it leads to a difficult conversation about, actually, do you want to fix it? If so, how can you fix it? So cases are still coming through on this. Right, staying with holiday pay, let's look at what are called part-year and irregular hours workers. Most often term time employees or workers, ad hoc, casual people. So the government has looked at this and said, for holiday years beginning 1st April next year, we get the return not of the Mac, Rachel. The return, I got a smile there, the return of the fabled 12.07%. Some of you will know what the fabled 12.07% figure is, I hope. It is basically the calculation of how much holiday somebody should accrue and therefore be paid when they are working during employment. We've had some cases during the year, Harper and Brazil, which has caused a huge amount of angst and uncertainty as to how much employees and workers should be entitled to be paid for holiday pay. The government has looked at this and said, okay, we're going to try and reduce some of that. So what we have for holiday pay is employees, workers will accrue at the 12.07%, and we can legitimize rolled up holiday pay from spring. So what that means is that if somebody is on a week, they're only going to be employed or working for a week. During the week, you can pay them X pounds, so national minimum wage, and then you can express this is your holiday pay within that so that they work the week and then they don't have an extended period at the end when they are on holiday for the week that they've accrued, or you have to pay them additional pay at the end of it. It's all within their pay, separated out clearly in the pay slip. So this is, I think, some good news and some clarity for employers who are struggling a little bit with some of the complexity in this area. But it doesn't solve all of the issues of Harper and Brazil that came up and that we've talked about many times in the past, but it is helpful nonetheless. And it is, two other final points, calculated over a 52-week reference period, which is good news. So it's over the so not a 17-week reference period. But it would be on somebody's total earnings, and that's what I would have expected. So if you're a normal hours employee, then it's on your normal pay. But if you're a ad hoc, casual, no normal hours person, so a part year or regular hours, we know the principle is that then it's your total remuneration, which is looked at to calculate the holiday pay. Okay. The snappily titled, I'm going to have to read this bit, Employment Rights brackets, amendment, revocation, transitional provision, close brackets, regulations 2023. That's Ron Seal for you, isn't it? They do exactly what they say. Funnily enough, they amend some bits of EU law and put it into, or enshrine some bits of EU law and put it into our law. Why are they doing that? Well, they think that actually this is a good idea to enshrine this so that we know it's our law. And it's stuff that we already know about. It's in the EU case law, and it's just coming into here and coming into play on New Year's Day. And what we've got is confirmation of if somebody's off sick, what happens to their statutory holiday. If somebody is unable to take their holiday, perhaps because they're not being treated as an employee properly, again, their holiday can be carried forward. So it's not lost at the end of the holiday year. So basically, it's clarifying what happens in certain circumstances. And it's also defining normal pay. And they're basically saying for holiday pay purposes here, normal pay is everything that would intrinsically be paid to somebody when they're carrying out their job. And it also talks about it being when it's paid regularly or regularly paid, but there's no clarification of what regularly paid means. I suspect we might get some clarification required on that in due course. Okay, well, let's move on to something that's actually happening almost right now. I say almost, I'll explain in a minute. I had to change this slide because on Monday, the government changed what they were doing. So we'd had heralded prior to Monday some changes to flexible working, and then the government made some further tweaks, published some regulations, and we had to interpret them. And so, this is the law in action. It is happening. So rather than coming into force, we thought in the summer, 6th of April, these are the changes to the flexible working regime. So currently, as I'm sure you all know, employee can make one request a year, provided they've got 26 weeks service. The employer has 3 months to respond and deal with it. And they go through a certain process, and there are 8 reasons to say no. Aside from that, we all know that with the flexible working, ideally you should be saying yes if you possibly can. Government is changing that. So in 4 and a bit months' time, 3 and a bit months' time, 2 requests in any 12-month period, a day one right, so abolition of the 26 weeks qualifying period, decision period, as it says on the screen, reduced from 3 to 2 months. You have to consult if you're considering rejecting the request. Well, I mean, that obviously, but the employee is no longer required to explain what the effect it would have on the employer if they implemented the flexible working request. So some changes, again, it's still only a request. It's not an entitlement to work flexibly, but you can see this is moving. You can see the direction of travel on that. Okay, slightly less exciting, perhaps, right to request more predictable contracts. So if you are somebody who is, let me find my notes, a person on a fixed term contract or on unpredictable hours, you have the right to request, again, not the right to have, the right to request certainty, more clarity of your flexible working pattern or your predictable working pattern. So it applies to everybody, workers, employees, including agency workers. If I'm on a fixed term contract, that's less than a year, I can ask for it to be made for more than a year or to be made permanent. We don't yet know if it will have a 12-week, 26 weeks, whatever qualifying period before I can make the request. But we do know, again, like with flexible working, it's 2 requests a year. As with flexible working, it can be rejected. The same 8 grounds we think will apply with flexible working to this. So this is coming. So you're going to have more certainty-ish given to employees and workers where they've got uncertain, unpredictable hours, being able to say, hello, I'd like some more certainty, please. Just a quick slide on what's coming. We know that relaxation of working time, record keeping requirements, not very exciting. We know that the introduction of carers leave and extension of redundancy protection for new parents, again, as of Monday, that's coming in on the 6th of April. Just one word on that. The redundancy protection is going to be 18 months from the EWC, the expected week of confinement, and it's giving redundancy protection, as the name suggests, to the person who is having the baby or adopting or whatever it might be. More on that as we go through. And as you can see, some other bits and bobs coming through in the future. I'm going to shut up. Some of you will be hopefully grateful for that. And I'm going to pass on to Greg, who's going to talk to you about the most thrillingly entitled 2 recent cases. Go, Greg.
Thank you very much, James, and well done for struggling through with your throat. It didn't notice it at all, so well done. Yeah, James was very disparaging of this introductory slide, saying 2 recent cases. We're not claiming the cases we're about to talk about are necessarily the most significant cases of the year or have sort of really changed the law in a significant way. But what they do is illustrate some of the points we often come up with or come up against, either as contract draftspeople, people who are trying to draft contracts on behalf of our clients to achieve their commercial objectives, or indeed when we're dealing with disputes and resolving disputes and looking at limitation and so forth. So we're looking at 2 cases. One relates actually to Russian sanctions and to force majeure and to payments in sanctioned situations. And the other one relates to the proper interpretation of a limitation or an exclusion of liability clause, and also a court's ability to look beyond the type of loss that's being claimed by the claimant and actually analyse what type of loss is actually being claimed. So if you'd like to move on to the next slide, please, James. So the first clause we're looking at, case we're looking at, relates, as I said, to sanctions payment and touches on force majeure. The case is Gravelor Shipping and GTLK Asia. And when you look at a case like this, it sort of very much brings me back to law school when we used to look at some of these sort of commercial cases and charter parties, etc. So this is actually a shipping charter party for sort of explanation or understanding what we're talking about here is there is an owner of two vessels, GTLK. They make those vessels available to Gravelor, the charterer, who uses those ships, makes payments during the period of the charter party, which we'll call the agreement, and at the end has the right to serve an option to actually purchase those vessels at the end of the finance arrangement. So, in a domestic arrangement, it's a bit like having a sort of hire purchase arrangement where you pay rental payments throughout the period of the agreement, and then you can pay a balloon payment at the end to have title to the relevant object transferred to you. The relevant object here is two rather large bulk freight ships. So the freight ships were acquired by Gravelor on this sort of finance lease type arrangement. GTLK, the owner of the ships, had a duty to transfer title to those ships when the final payment had been made. Important factor here, as we'll soon see, is that GTLK was ultimately owned or controlled by the Russian Ministry of Transport. So you've got a Russian government body further up the corporate chain. So that's the situation we've got ourselves in. Let's see what happened in 2022. Next slide, please. So, as I'm sure you will all remember, February 2022, Russia invades Ukraine, 24th of February 2022 to be precise. I know that date well. It's my wife's birthday, and I must never, ever forget it. Otherwise, my life will be a misery. So, Russia invades Ukraine on 24th of February 2022. Under the terms of the Charter Party, under the terms of the agreement, Gravelor says it expresses its intention. It does plan to make these final payments and actually purchase the vessels at the end of the arrangement. That's what it wants to do. As a result of the Russian invasion of Ukraine, both the EU and the UK introduced certain sanctions, asset freeze sanctions, stopping the sanctioned organisations from being able to access, move their assets, their finance, etc. And we will remember lots of stuff happening around that time, including at Chelsea Football Club and other interesting things. So EU sanctions and UK sanctions are introduced. June 22, move on a few months later, Gravelor then serves the notice under the Charter Party agreement to actually purchase. So it's been making its payments. It now says, I'd like those two big ships, please. Here's my notice saying, please hand over the ships when I make the final payment. And as we see in September, there's a further introduction of sanctions, this time by the US, and those are blocking sanctions, so blocking certain transfers, etc. So you've got on the bottom line there what's happening under the contract and under the arrangement. On the top line, the wider political environment. So could we go to the next slide, please, James? So what was the impact of the sanctions on the parties? So really important, up until the time of the Russian invasion of Ukraine, Gravelor had complied with all of its obligations under the agreement and had made all payments. So everything was tickety-boo. Gravelor was completely compliant, paying for the ships and intended to purchase them. But as a result of that asset freeze, the EU asset freeze, Gravelor was unable to make a number of further payments to GTLK because it wasn't allowed to do so because GTLK was a sanctioned organisation. And the transfer of the vessels would be blocked because under the sanctions regime, it was not possible for GTLK then to transfer the vessels to Gravelor. GTLK, so the owner of the ships, I think quite interestingly, claimed that this was an event of default and therefore said, okay, you, Gravelor, you're in default of the agreement. So under the terms of the agreement, we're going to call for accelerated payment, i.e. all the further payments which are meant to be made over the remaining term of the contract have got to be paid now. And you've got to pay that money in US dollars into a Russian account, known as in the case as the Gazprom account, and probably lots of you know Gazprom, big prominent Russian organization. So GTLK says, well, you can't pay because of the sanctions, therefore you're in breach, give us all the money and give us a load of US dollars into our Russian account. My hunch is, given that it was owned by the Russian ministry, they knew that that could not happen. They would not be able to access US dollars, and they knew that money could not come into that account. Gravelor said, well, actually, no, the effect of the sanctions is that we can't pay those sums due in the required currency. We're not allowed to pay you US dollars, and we're not allowed to pay you into that Russian account in Moscow. Sorry. GTLK said, well, look, in that case, if you can't pay us the money into the account in dollars, we're not going to transfer you the ship. We can't do it. So actually, they've got to this sort of impasse now as a result of the sanctions. One party saying, I want to make the payments, but I can't. The other party saying, well, because you can't make the payments, I'm going to accelerate the payments and you're in breach. And by the way, you can't have our ships. No. So that's what happened there. They probably did do that at some point, I'm sure. And then what, interestingly, I think Gravelor did is then they applied for specific performance of those purchase options. So they actually went to the court and said to the court, you have to force the GTLK to actually perform the performance options so we can buy the ships. And they did that relying on clause 8.10 of the agreement. And with a click of the button, hopefully we'll see what clause 8.10 says. Hooray. Sanction payments. So basically, payments under the charter party, the agreement, where they're incapable of being paid to a relevant banking institution and has not been received by the owner, GTLK, by the due date, by virtue of GTLK becoming a sanctions target, then the owner and the charterer, so GTLK and Gravelor, shall cooperate and promptly take all steps necessary in order for the payments to be resumed. And then it specifically went on to say any delay resulting from those circumstances won't be an event of default as contemplated by another clause in the contract. So what's slightly lost to me is it was so clear from this clause that non-payment wasn't, in these circumstances, wasn't an event of default. It's quite hard to see why GTLK claimed it was an event of default. That's sort of lost in the details of the case. The really important thing, though, is the first sentence there, which says that the parties, the owner, GTLK, and the charterer, Gravelor, have to take all necessary steps in order to try and make get those payments resumed. So what Gravelor did is it went to the court, referred to this clause, and says we want GTLK to comply with the agreement on the basis of this sanctioned payments clause. So if we look on to the next slide, please, James. So what was the court considering? Number one, the impact of that payment sanctions clause you've just seen. So what is the impact of that clause within the contract? Whether the sums due under the agreement had to be paid into the Gazprom account, i.e. did they have to be paid into this nominated account in Russia? And whether those sums actually had to be paid in US dollars. So it looked at those three issues. No, that's fine. You're ahead of me. You're obviously reading the case and enjoying it. I'm very pleased. So what's the court? Yeah, so. Okay. I'm just seeing whether I've had a few joiners rather than leavers during my bit, so I'm happy. We're going up rather than going down. Please don't leave now. So clause 8.10, basically the court said actually, and it's pretty clear from the face of that clause we just looked at, it requires the parties to cooperate and take all steps necessary to deal with the payment difficulties caused by the sanctions. So there was a clause in there that said, look, you've got to take reasonable steps. Just because the Gravelor was not able to make those payments into the Gazprom account, what the court said is GTLK actually needed to nominate another account, an unsanctioned account, in which payments could be made in another currency, even if that meant that GTLK, the owner, could not access those funds either immediately or perhaps ever. It said you GTLK have got to find another account and accept payment. The court went on to say that payment into the blocked account, i.e. the one from which they couldn't access money, did constitute payment for the purposes of the contract. And obviously in looking at that, what the court observed was there was this sanctioned payment clause in there. So the recipient, the parties had already given some thought to the fact that GTLK might become sanctioned. And because they'd done that, they really expected the parties to comply with that clause 8.10 and take all reasonable steps. So even if the result of that was GTLK couldn't get its money for some time or ever, the court was prepared to interpret the contract and require slightly different payment method to be made, and said that was contractual payment. The court took into account, obviously, it was detrimental to GTLK being unable to access the funds. However, the consequences for Gravelor of not being able to make the contractual payment would be significant, i.e. they'd paid for these ships over a series of payments, and all of a sudden, through no fault of its own, because they weren't the sanctioned party, GTLK was, they were in a situation where they wouldn't be able to complete the contract and eventually, and I say eventually, purchase the ships, because there was still then the problem of could the ships be transferred out of sanctions anyway. But that's what the court looked at, and that was the decision made. James, could you just pop on to the next slide? So what are the lessons from this case? Number one, and I say this when we report all cases turn on the facts and set of circumstances. I mean, this is very fact specific. But what I would say is don't immediately assume that force majeure applies. So this comes up a lot when we're looking at cases, and going back to the horrible days of the pandemic, the number of people said, there's this pandemic, that's just force majeure. I'm just going to call force majeure and I don't have to do anything, do I? And you've got to look at the force majeure clause. You've got to look at what it says about, for example, is it unable to comply with the contract despite its reasonable endeavours, things outside its reasonable control. Does that include, for example, government sanctions, government actions, etc., changes in law? So always look at the force majeure clause and don't just jump to the assumption that something like this is force majeure. Really importantly, if a specific clause is included, the parties are expected to follow it. The parties have put their mind to it in clause 8.10. The court held them to that. So those top three, to me, are the more sort of generic or general points we can get from this case, and applies to all cases. So don't immediately assume force majeure, and if you've drafted a clause, make sure you follow it. The next three are probably a bit more specific to this whole sanction situation, but what it does show is that courts are willing to find that party may have to accept performance which is not strictly in accordance with the contract terms, but it does enable the other to comply with its payment obligation. So GTLK had to accept payment into a different type of account in a different currency, and the court ruled that it should do that. Also demonstrates that in certain of these types of situations, might be difficult for parties to argue just because sanctions have been imposed, it prevents them from making or receiving payments, i.e. there may be other ways you can find other accounts to make payment into, other interim measures while the sanctions are in place. And for those people, some of the commentary for sort of people who deal with international trade a lot, I've seen commentary suggesting that there was a feeling that this is actually moving in the direction of trying to protect a bit more those people, parties to contracts, who aren't the direct targets of the sanctions. So in our situation, Gravelor wasn't a sanctioned organisation, but it would suffer as a result of the sanctions. And this looks like a way of the courts trying to find a way of sort of looking after parties in those circumstances. So those are the key lessons from the Gravelor case. If we can move on to our next one, please, James. This is an exclusion of liability clause. What we always say about exclusion of liability, the key thing is the devil is in the detail. It is how it is actually drafted. You've really got to look at what the clause says, what it includes, what it excludes, what is limited. This actually comes out of a set of events which are actually quite old now. It happened some time ago, but this is EE Limited, network operator, versus Virgin Mobile Telecoms Limited. It was a court decided earlier this year. The background to that was Virgin Mobile was actually an MVNO, which is a mobile virtual network operator utilizing other operators' network. So what's an MVNO? An MVNO is somebody who doesn't have its own network. It doesn't have a license to run a network, but it resells network time to customers. So Virgin Mobile never actually had the infrastructure, the masts, and all that sort of stuff for the mobile network. It effectively leased that on a wholesale basis from other suppliers. And at the time, there were a number of people who had those licenses. Originally, Orange, T-Mobile, Vodafone, etc. Orange and T-Mobile, I think it was, who emerged and became EE. I would also say that there is a bit of another background to this, which is over the period of the events covered by this case, there were quite a few changes at Virgin and its plans. So it was going to move away from EE in any event and to Vodafone. And then for those of you who follow the sort of telecoms industry more closely, actually what ended up happening is Virgin Mobile merged with O2, and basically everything is now on the O2 network, and actually Virgin Mobile isn't being sort of sold as a standalone product anymore anyway. So there was some sort of corporate mergers and some strategic shenanigans going on in the background in any event. So in 2013, so I say going back quite some time ago, Virgin Mobile and EE enter into a telecom supply agreement, TSA, And under that agreement, EE was required to supply various services to Virgin Mobile. Those services included providing access to EE's network to enable Virgin Mobile's customers to be provided with 2G, 3G, and 4G mobile services. So all the Gs that are available at the time, you could get them under that. And the TSA itself was a lengthy agreement, very complex, very bespoke, but it included an exclusivity clause for the benefit of EE, i.e. what that meant was Virgin Mobile could only use EE to provide services, 2G, 3G, and 4G mobile services to customers. So it was tied to EE at the outset of the agreement in 2013. Can we move to the next slide, please? So in 2016, some amendments were made. So 2016, the TSA Telecom Supply Agreement was amended to allow Virgin Mobile to provide 5G services to customers. So we've got a new G, 5G. So we bring that, and I just have to say as an aside, isn't 5G rubbish? It's really slow. It's the worst G. If you're ever on 5G and it's going slow, change your phone, go into your settings and change it back to 4G. It's much quicker. At the moment, I'm sure there's reasons for that.
Wow, what you're getting people here is not just legal updates, but practical G advice from GG.
Very good. Very good.
You
Thank you, GG.
just remember where you were at this moment.
Yeah, I hate 5G. It's the worst G. Anyway,
Yeah, that came through, Greg.
Right. Okay. So what did the amendment agreement state in relation to EE? It said that VM, so that if EE and VM could not agree for the provision of 5G services using EE's network, then Virgin Mobile could enter into an agreement with a different network to provide 5G services to its customers. So 5G is going to be introduced. EE and Virgin Mobile then have a discussion about the terms under which they're going to use EE for 5G. If they can't make that reach an agreement, they can then VM is then able to go off to other suppliers, other networks, and enter into a deal. Actually, what Virgin Mobile ended doing, they couldn't enter into an agreement, they couldn't agree terms for 5G under the EE network, so they moved over to Vodafone and they sourced their 5G services for customers from, I'm jumping ahead. What the changes to the agreement said is that if Virgin Mobile did move a customer to a different network to access 5G services, it could also then take that customer to that other network for 2G, 3G, and 4G. Otherwise, you're in a situation where your 5G services are on one network and your 2, 3, and 4G services are on a different network, and that actually causes you problems with handover from network to network as you move from 4G to 5G. So there were practical reasons for doing that. I've already given the game away slightly, but let's move on to the next slide. In my excitement and my disparaging of 5G. So what happened? 5G was launched. So EE launched its 5G services in 2019, but following an inability to agree terms, technical terms or whatever, Virgin Mobile actually sourced 5G services from another supplier, Vodafone. And then from 2021, Virgin Mobile began to migrate customers from EE to the Vodafone network. So it's starting now moving customers across to Vodafone. Next slide, please. So Virgin Mobile argued under the amendment agreement that it put in place that it was able to have a separate arrangement with another mobile network. So they said we're allowed to do this, there's no breach here. EE thought that Virgin Mobile was actually acting in breach of the exclusivity provision. And why was that? It was saying because not only had Virgin Mobile started moving over people who were taking 5G services to Vodafone, they were also moving over new or offering new non-5G customers, i.e. 2G, 3G, and 4G customers, Vodafone. So if you're a new customer to Virgin at that point, Virgin started putting you directly on the Vodafone network rather than the EE network, and EE said, well, that was a breach of the exclusivity because they've got an exclusive arrangement. The only time you could break that is if you offered somebody new 5G services, you could then take their 2G, 3G, and 4G services away. So EE brought a claim against Virgin Mobile for loss of revenue, and quite a lot of loss of revenue, 24.6 million, as a result of the diversion of customers to Vodafone from EE. So there's a claim now at the court for 24.6 million. We have to look at the exclusion of liability clause. We can actually sort of, for these purposes, actually ignore the introduction to it, but it says, except for certain types of claims, in which case there might be a claim for loss of profits, and for no other damages claims whatsoever, neither party shall have liability to the other in respect of anticipated profits or anticipated savings. So a claim had been brought by EE for loss of revenue, But Virgin Mobile actually argued that EE's claim was not for loss of revenue, but was actually for loss of profit. And because it was a loss of profit claim, it would have been excluded under this clause because it was a loss of anticipated profits, the profits that would have been made had those people not been diverted over to Vodafone and had continued to use the EE network. So that was the clause we were looking at. Next slide, please. So what did the court decide? So actually, the court decided that EE's claim was not for a loss of revenue. It said it wasn't a claim in debt for charges due under the TSA, the Telecom Services Agreement, because these customers who had been diverted were never on the TSA, so that, there were no charges to be paid. There was no wasted costs for EE because actually once you've got your network set up, the marginal cost of bringing new users on is pretty minimal. You've got all, you've buried the cost of building the network. So the court said this was a claim for damages for diversion away of for the diversion away of customers to the alternative service provider, i.e. to Vodafone. So although EE sought the claim for a loss of revenue, the court said the proper construction of that was it was a loss of profit claim because it was trying to recover the profit it would have made had those customers used the EE service in the first place. And because it was a loss of profit claim, Virgin Mobile's liability was completely excluded effectively because of that exclusion of loss of profit or anticipated profits in the exclusion clause. So I haven't gone into and time doesn't allow today to go into the ins and outs of some of the detail of was it a loss of revenue or was it a loss of profit, but it does illustrate quite well that despite the claim being made as a loss of revenue claim, the court was prepared to say, no, it's something different. So what lessons do we have here? Just two, I think, on this one. So really, from the contract draftsperson point of view, a reminder of the importance of clear drafting in exclusion and limitation of liability clauses. And this is just an example actually here. So for example, had the parties intended to exclude liability for loss of revenue, they could have done so and they should have made that clear. Obviously, that wasn't really the argument here. The argument was actually about one party saying it was loss of revenue, the other saying it was loss of profit, and loss of profit is excluded. But it just illustrates that point that you've got to be really careful. And what are you excluding? Do you list them out? Loss of profit, loss of revenue, loss of anticipated savings, etc., etc. Which is why, rather frustratingly, some of these clauses become quite long. So that's one thing. Get the drafting right. Be really clear. And also, and this is more a litigation point, really, more Rachel's area than my area, but courts are willing to look at claims that are stated to be a claim for one type of loss and actually say, no, you've misstated that claim. This is not a loss of revenue claim. This is a loss of profit claim. And Rachel's even come off mute, which makes me think she might be about to say something.
No, I was just getting ready for my slot, Greg.
Oh, there you go. Sorry. Is there anything you want to say before we hand over to your slot?
Yeah, I mean, I think that's a good point. The courts are willing to look at the nature of the loss rather than the strict wording, because in the true sense it was a loss of profit claim as opposed to a loss of revenue. So they were willing to be flexible in that approach. But I totally agree. Why run a case all the way to trial on an issue that could have been dealt with in the drafting?
Yeah, and presumably, sorry, Rachel, presumably EE knew that they couldn't make a loss of profit claim because it would be excluded anyway. So
so they're trying to formulate it in a different way. Exactly.
Yeah. Okay, that's really helpful. And that is the end of my slides, James. Thank you.
Thank you. So we've learned about sanctions and freight ships. That doesn't sound right. And we've learned about all the G's. Thank you, Greg.
All the G's, including GG. Very good. Thank you.
Rachel, what are you going to thrill us with?
So I'm going to thrill you with the Economic Crime and Corporate Transparency Act 2023. And I'm going to try and say Economic Crime and Corporate Transparency Act as few times as possible because it's a bit of a mouthful. I wanted to take my slot and cheat a little bit and not look back at key developments, but actually look forward towards two particular new developments that are being brought in by the Act. And I'll start this section by saying there are other developments brought in by the Act, but as a disputes lawyer, I'm particularly interested with two new aspects. If you move to the next slide, those aspects are the new offence of failure to prevent fraud, which is coming into force at a date to be determined next year. And the second is the broader change being made to the principles used to determine criminal liabilities of corporate bodies. Now, that's coming in a lot sooner, on the 26th of December this year. And I'm going to talk you through in a moment what those changes look like in practice. But what essentially it means is that it will now be significantly easier to prosecute companies for certain economic crimes. So looking at the next slide, the new failure to prevent fraud offence. So what is it? Essentially, if a person associated with a relevant body commits a specified fraud offence, which is intended to benefit the relevant body or any person or subsidiary the associate is providing services to on behalf of the relevant body, then that relevant body will be guilty of the offence of failure to prevent fraud. So let's sort of break that down a little bit. First and foremost, it has to be a person associated with the relevant body, and they must have committed a fraud offence. Now, the specific offences can be found under Schedule 13 of the Act, and they're listed there, and there are quite a few of them, but they do include things like the common law offence of cheating the public revenue or false accounting under the Theft Act. And it's worth mentioning that if the associate is merely simply aiding, abetting, counselling, or procuring the commission of the offence, then the corporate may still well be caught in terms of committing that failure to prevent fraud offence. The relevant fraud offence must be committed, as you can see on the slide there, with the intention to directly or indirectly benefit either the organisation itself or any other person to which the associate is providing services on behalf of the organisation. But what's really interesting, I think, is that it appears that it's not really going to matter whether the organisation or the recipient actually benefited from the fraud. So whether or not they actually benefited, it's really about the intention of the individual who committed the offence in the first place. If they intended to directly or indirectly benefit, then that will be enough. So moving on to the next slide, the applicable fraud offence has to be committed by an associate. Now, what is an associate? Well, it includes employees, as you might expect, but also agents and subsidiaries of that body, and persons that otherwise perform services for or on behalf of the relevant body, which is a pretty broad definition, mirrors quite similarly, I think, the one in the failure to prevent bribery offence. But what is the limiting factor here, where there isn't such a limiting factor in the failure to prevent bribery offence, is that it only applies to relevant bodies, and that might make some of you breathe a bit of a sigh of relief, because there is a definition there of a relevant body, which includes bodies corporate, partnerships, whether unincorporated or not, which does mean that large not-for-profit organisations and public bodies will be in scope. The relevant body must be a large organisation. You can see on the right-hand side of the slide there the definition of a large organisation, where two or more of those factors must be satisfied. So it will only bite against those who are large organisations, but equally, the definition of a large organisation mirrors that in the Companies Act, and is in some ways open to interpretation. As you can see, there's different questions there that you need to consider. So if we move on to the next slide, it is worth noting that the Act is silent on jurisdiction. So the government fact sheet that's been put out with the Act states that the failure to prevent fraud offence will not only apply to UK bodies, but also non-UK bodies if that employee of the overseas body commits a fraud under UK law or targets UK victims. So that's a really wide scope there to consider. And you'll be also perhaps pleased to know that there is a defence to the offence, which is reasonable procedures. So if the relevant body is able to prove that at the time the fraud was committed, it had in place reasonable prevention procedures, then that will be a defence. Quite similar again to the defence to failure to prevent bribery. It's for that reason that it's going to be paid to be prepared before that offence comes in, so that if the worst happens, you do have the opportunity of using that defence. Just to flag that the fine for an organisation can be unlimited, but of course courts will take all of the circumstances into account. And also that it will be possible for organisations to enter into deferred prosecution agreements, or DPAs, in a similar way that they can do under the Bribery Act, which, just by way of recap, means that you can allow for the suspension of the prosecution, during which time the organisation meets certain conditions and the prosecution is then terminated. So it enables corporates to avoid formal prosecution without any formal requirement to admit criminal liability. So DPAs will be available, and that's been confirmed. We still don't have a date for the failure to prevent fraud offence to be coming into force, but we do know it will be at some point next year. And the statutory guidance on prevention procedures is expected to be published in the spring. And realistically, that guidance is going to be very, very helpful indeed in preparing for the new offence and what reasonable procedures might look like. But larger organisations where a lot of work is needed may well be thinking about their preparation before then, because there's going to be there is only going to be a short lead time. So that's the new offence. Now I just wanted to touch on corporate criminal liability. The new Act also introduces a major reform to what's known as the identification doctrine, which is the principle used to determine criminal liability of corporate bodies in respect of economic crimes. So as many of you might know, under common law at the moment, in order for a corporate body to be found liable for an economic crime committed by someone within the organisation, the individual who committed the offence needs to have been essentially the directing mind and will of the organisation or an embodiment of the company. Now, this is ordinarily interpreted as a board member or the CEO, for example. And it's relatively easy in the respect of small companies and organisations to identify someone with this position of responsibility. But as we've seen played out in the press over recent years, for multinational organisations, and spanning numerous entities and different jurisdictions, it's much, much more difficult. And we certainly have seen the SFO struggling to prosecute corporates, large multinational corporates, even where the most senior individuals at large organisations have been considered as having committed offences, because even those were not the directing mind and will. And so this has been coming for a while, I think, these changes. The Act is introducing an alternative test, which is aimed to reflect managerial complexities. So under the Act, this element of which comes into force on the 26th of December, if a senior manager of a corporate body or partnership acting within the actual or apparent scope of their authority commits a relevant offence, then that corporate body or partnership will also be found liable. So huge broadening there. Instead of directing mind and will, you're moving towards senior managers. And it's worth flagging that there's no defence available to organisations under that statutory test. So they don't even need to be aware that the relevant offence has been committed in order to be found criminally liable. And it's not, unlike with the new failure to prevent fraud offence, it's not going to be necessary for the senior manager to have intended to benefit the organisation when they committed that relevant economic crime. So who is classed as a senior manager? That's someone who plays a significant role in making decisions about the whole or substantial part of the activities and how they're going to be managed or organised, or a significant role in the actual managing or organisation of the whole or a substantial part of those activities. Now, we're yet to receive any guidance as to who constitutes a senior manager, but the language of the Act actually mirrors the Corporate Manslaughter and Corporate Homicide Act. So it's likely to include top-ranking managers and regional managers in charge of regions being a substantial part of the activities. The focus is really on someone's responsibilities and influence as opposed to their job title. In terms of what offences are included within this, those are listed in Schedule 12 of the Act, and they include numerous economic crimes, such as money laundering offences under the Proceeds of Crime Act, offences caught by the new failure to prevent fraud offence, fraudulent trading under the Companies Act, and also offences under the Financial Services and Markets Act as well. And it's worth flagging now as well that the Covenant actually intends to extend this statutory test for all corporate crime and criminal liability, rather than just economic crimes. And in as recently as the 14th of November this year, a new bill had its first reading in the House of Commons, which actually repeals this statutory test under the Economic Crime Act in order to apply the test to all criminal offences. So what we can do to prepare now. So as I said, the alternative test of corporate crime criminal liability and this new senior manager widening is sort of imminent, 26th of December. And while there are issues which are similar to or overlap the failure to prevent fraud offence and the preparations that might be taking place there, now would be a good opportunity to identify any senior managers within the organisation to ensure they've received the appropriate training. It's not going to act as a defence to organisations, but it does show that you're taking these issues seriously and making sure that senior managers are aware of them. And I have been talking to clients about this quite recently, because the basic principle, of course, is that your senior managers should understand that they shouldn't be committing criminal offences. And so from that perspective, very little changes. And organisations equally may not want to nail their colours to the mast by potentially doing a prosecutor's job for them and creating a list of senior managers from their perspective. But nevertheless, it would be helpful to cast the net wide and make sure that everyone within that wide net has had the appropriate training, for example. Secondly, on the slide there, you can see conducting a fraud prevention and detection policies review to make sure that they're in line with the new legislation, and risk assessing in order to identify any vulnerabilities in the procedures and controls. There's no doubt going to be need to be ongoing review and consideration of how procedures interact. For example, you're going to be looking at your procedures that are most at risk here, so purchasing, accounting, whistleblowing, etc., anti-money laundering and anti-bribery. And before the new Act comes into force, now is a good time to consider what, if any, response strategy your organisation already has in place when fraudulent activity is identified, and put that response strategy to the test. This could include, for example, identifying a team of individuals responsible for enforcing the strategy, thinking about internal investigations, considering whether external input is needed by, for example, IT specialists. And finally, and probably the most important thing, is watch out for the government's statutory guidance on prevention procedures ahead of the introduction of the failure to prevent fraud offence. That's currently expected in the spring. So we'll probably have a lot more to say on that in the new year. Do keep an eye out.
Thank you, Rachel. I'm not sure it was thrilling, but certainly concerning, if you don't mind my saying. Rachel looks offended by that. Thank you to Greg and to Rachel. Thank you, everyone, for attending. As you leave, there'll be a pop-up. Please, as I said earlier, give us some feedback. There will be a copy of this presentation. I wish you all a lovely festive season, and we'll see you all in 2024. Take care.